Welcome to Law Lunch on the Margaret McLean Show. It's your midday legal briefing where we break down the biggest courtroom stories, explain what they mean, and separate the headlines from the law. So, I'm Margaret McLean, a former prosecutor, civil trial lawyer, and law professor. Be sure to subscribe because every weekday at noon we'll translate the legal issues shaping the cases everyone is talking about. And today's story is another major development and the ever expanding fallout from the Karen Reed case. What began as a single homicide investigation has now evolved into multiple civil lawsuits, challenges to criminal prosecutions, internal police investigations, and growing questions about public trust in both law enforcement and the justice system. So today, yes, today at 3 o'clock, Judge Gildea, who sits in the Plymouth Superior Court, scheduled an in-person hearing in the wrongful death civil case brought by the O'Keefe family. He ordered every lawyer involved in the case to attend. So it sounds like I'd say he's a little bit angry, and appears like somebody out there, hopefully not one of the lawyers, leaked information. Okay. So before we dive into Judge Gildea's latest rulings, let's take a step back and remind everyone what this Plymouth Superior Court case is actually all about. So last year, around this time, we were embroiled in Karen Reed's criminal trial. That case ended when a jury acquitted her of second-degree murder and manslaughter, but while still convicting her of operating under the influence of alcohol, which was a big win for Karen Reed. So let me show you a slide here that I've prepared. It's, of course, the law professor in me. So here we go. And this is the civil wrongful death lawsuit, which was filed in late 2024 by the family of deceased Boston police officer John O'Keefe. And that's John's brother Paul right there, who you probably, if you watch the trials, sat in court sat in court, I think, every day. So the plaintiffs are family members and the estate of John O'Keefe. They've sued Karen Reed along with two Canton bars, C.F. McCarthy's and the Waterfall Bar and Grill, for over serving Reed too much alcohol. The lawsuit, and I'll take him down, I'll put myself on there as well. All right, here we go. That's me. And I'll put him back up there. Okay, so the lawsuit alleges that Karen Reed caused John O'Keefe's death by striking him with her SUV and leaving him there to die in the snow. It also claims she intentionally inflicted emotional distress on the O'Keefe family by promoting what they characterize as a false narrative about how he died. The family is seeking damages for wrongful death, pain and suffering, and of course, emotional distress. Reed denies the allegations. As part of her defense, she maintains that she was wrongfully accused and that others bear responsibility for what happened to John O'Keefe. She believes the people in the house at 34 Fairview in Canton and the police were involved in a conspiracy cover-up to frame her. We're in the discovery stage now in these civil lawsuits, which means the parties will send written questions that must be answered under the pains and penalties of perjury. These are called interrogatory questions. And also, depositions are a major part of discovery in civil cases. They are typically held at an attorney's office with the lawyers and the person being deposed. They're videotaped for the most part, and a transcript is created. Now, they must be completed by certain times, and judges, they like to stay on schedule. So Karen Reed's deposition has actually been taken, but I'm not sure it's completed. And these depositions can take, usually, especially for her, it's going to take several, maybe two to 3 days. And Trooper Michael Proctor's deposition, which has been delayed, well, it was delayed before, it actually has begun, but it is not finished yet. And I can imagine they're really going to question him. I'd like to see him beaten up in the deposition. I don't like that guy. So that brings us back to Judge Gildea, and I'm going to point to another slide here. Here's the judge on the left. And then we, of course, have Karen Reed and John O'Keefe in the same slide. So Judge Gildea, he has paused all discovery involving corrupt and disgraced and fired Trooper Michael Proctor after learning information that, in the judge's words, supports a reasonable inference that a court impoundment order may have been violated. So this hearing that's occurring today, let's see, a few hours from now at 3 o'clock, it's really all about protecting the integrity of the judicial process. Judges take violations of impoundment orders seriously because parties and attorneys must have confidence that court orders governing confidential information will be respected. When judges believe that confidentiality orders may have been violated, they often stop proceedings until they understand exactly what happened. This protects parties, witnesses, the integrity of litigation, and of course, again, public confidence in the court system, in the justice system. The fact that Judge Gildea ordered every attorney of record to appear tells us he believes this issue potentially affects everyone participating in the case. Now, just so you know, again, another translation thing, an impoundment order means that certain court filings cannot be publicly disclosed. And why is that? Because they may contain medical information, confidential investigations, private communications, attorney-client privilege, and sensitive discovery. If those materials are shared outside the limits imposed by the court, judges take that very seriously. So that's my next slide here. We'll find out what happens, and I'll be covering that, and it'll be very interesting to cover that as well. I actually have to be in court, so hopefully I will come back to be able to cover that. Now that's this is let me make this a little bit bigger. This is actually the order by Judge Gildea. I'll put it up, take me off. So just so you know, this is what it looks like, signed by the judge electronically. Sorry, it's cut off a little bit on one side, but the plaintiff and defendant and each counsel with a notice of appearance in this matter of June 8th, 2026 shall file with the court on or before 4:30 on Tuesday, June 30th. So that was yesterday. A certification under the pains and penalties of perjury as to all facts known to them about any dissemination to anyone about this private material other than parties and counsel in this manner of any of the contents of the material impounded by the order on June 8th. So this is actually, this is pretty serious here. That this order went out, but who's going to admit it? If you leaked, if you're an attorney that leaked, are you going to admit it? If it's under the pains and penalties of perjury and somebody lies and they're caught, maybe they could be disbarred. It's a very serious offense. So I will, as I said, keep you updated. And of course, there's Good and Proctor. These guys are bad. We've got to listen to some of my other shows and subscribe to the channel, because these two had years and years of the most offensive text messages that I have ever seen, racial, anti-Semitic, anti-gay, you name it, absolutely disgusting, plus disgusting photographs. So, we've talked about that. So the next slide I have here, actually, this is very interesting. This is another lunchtime news of the day that I wanted to bring up. This is Myles King. I can take off the orange glasses. I lost all of my other glasses except for these bright orange ones. I don't know. I leave them at restaurants, I guess. So the Myles King case, legally, it may become one of the most important cases involving Michael Proctor, disgraced Trooper Michael Proctor. King is charged with M-ing or whatever, murdering Marquis Simmons. His attorney is asking the court to dismiss the indictment. Now, that's a big ask. Dismissal is one of the most drastic remedies available. The defense argues that Michael Proctor's documented anti-Black bias infected the investigation, and simply proving somebody made racist comments, though, is not enough. So you can't just say, oh, he made a racist comment. It's got to be more than that. So I am going to show you what I have up here is the actual motion to dismiss and some of the language. I'm not going to read the whole thing, or it will be dinner time. So we don't want that. But I'm going to put this up. Got to remove Myles King for a second. And adding this to the stage, get rid of me. And this is the defendant's second supplemental motion to dismiss that was filed. So where I think it's right here in this third paragraph really says it all. Well, kind of, but these recent disclosures demonstrate egregious misconduct on the part of the Commonwealth. Proctor's texts and photographs reveal such deep-seated and atrocious racial animosity that infected the entire investigation in violation of King's rights under the 6th and 14th Amendments to the United States Constitution and Article 12 of the Massachusetts Declaration of Rights, that such dismissal is required. So basically, in this case, the defense has to persuade the judge that those attitudes materially affected investigative decisions. And I'd say materially. It's got to be something that really impacted the investigative decisions. For example, Proctor's bias infect the witness interviews, evidence collection? Were leads ignored? Were suspects excluded because of his deep-rooted bias? And of course, that's a much higher legal hurdle for dismissal like this. So this criminal case, so I'll put myself back up again here. Let's see. Oh, there I am. Still not so good at tech, but I'm really getting better, I think. So this criminal case of Myles King is responsible for exposing to the public all of those disgusting racist, anti-Semitic texts between Good and Proctor that I've been discussing on previous videos. So subscribe and check them out. And you may like my interview with former State Trooper Todd McGee. We really get into what the state police response is about these texts. So he's wonderful. Check that out at the Margaret McLean show. Now, what courts will do is they'll ask, did the misconduct actually prejudice the defendant? Did it deprive the defendant of due process? Did it undermine confidence in the fairness of the investigation? In my opinion, I'm telling you, the Myles King motion is going to be a big one, and I will be following that as much as possible. I'll probably go to court for that one. And so please stay tuned on that, because I almost hope I feel bad for the victim in that case. I really do. I feel awful for any murder victim that's going to be impacted, but the government must be held responsible for these the vile behavior of Trooper Proctor and Sean Good as well. So speaking of Sean Good, that's another bit of lunchtime news. There's an independent investigation that was released by Canton, the town of Canton, and it's significant. It concludes that Good violated multiple departmental policies, and it recommends. Let's go back to Good here. Let me take this down. 2 seconds. Add to stage. We're going to go back to, there he is. I'm sorry, but So Canton concluded that Good violated multiple departmental policies and recommends permanent disqualification from law enforcement. Now, this is an administrative finding. It's not a civil or a criminal case. An internal investigation will ask, did this officer violate department rules? I also do not think this guy deserves any type of pension, and I hope he doesn't get it. Another issue, another thing I'd like to bring up here at lunch is Judge Gildea's discovery rulings, I think, are very interesting. It involves the Massachusetts State Police emails. So Karen Reed wanted hundreds of emails and from the state police, and the state police argued they were protected by work product. Judge Gildea agreed that work product protection survives after litigation ends. And that's actually an important legal principle that I want to go over. Many people think that once a criminal case ends, every document becomes discoverable, and that is not true. In fact, attorney strategy, legal opinions, and litigation prep often remain protected, especially under attorney-client privilege. However, Judge Gildea also ruled that simply claiming work product, it's not enough. So he ordered the state police to produce a privilege log. So what that means is they'll have to identify who sent the email, when it was sent, the basic or general subject matter of the email, why the privilege applies, and only then can the judge determine whether each document should remain protected. We also have the Colin Elbert deposition. So Karen Reed wants to depose Colin Elbert. And if you recall from the trials, he's the teenager who was at 34 Fairview, but allegedly left early. She wants him under oath. She wants to ask him questions. Does he know anything? Does he know anything about any type of conspiracy? Can her attorneys break him? Now, his attorneys say he's just unavailable because he's in Army basic training. Judge Gildea hasn't forced the deposition, but he also hasn't ruled it out. Instead, he's gathering more information. So in addition, I also thought you may like to hear a discussion I had with attorney Peter Ellikin about, he's a great defense attorney, about the 4 lawsuits that have been filed pertaining to the Karen Reed fallout. So we briefly discussed each one and provided our opinions on the merits. So I'll play that for you, and I think it's interesting to get his perspective. Of course, it's my perspective as a prosecutor, former prosecutor, and his as a criminal defense attorney. So I am going to play that now, and then I will be right back. Let's see if I can find it here. Aha, here we go. Let's talk about the further fallout. We've got the 4 lawsuits, Karen Reed civil suits, right? 4. So talk about the legal maneuvering. Number 1, we have the wrongful death lawsuit filed by the O'Keefe family. They allege that Karen Reed drove drunk, struck John O'Keefe with her SUV, and left him to die in the snow. And this is, in fact, just the case we just saw with Michael Proctor. He was scheduled to be deposed on Monday, yet he got a continuance for some, we're guessing, unknown medical conditions. We've got that one. And then number 2, and then we'll go back through and talk about them a little. Number 2, Karen Reed is also suing 5 witnesses in federal court, So you have the House defendants, Brian and Nicole Albert, Jennifer and Matt McCabe, ATF agent Brian Higgins, and then Yuri Buchanan. And Brian Tully, Michael Proctor are also in that one. She's alleging a coordinated effort to frame her. So that's a big one. Then number 3, you have Jennifer McCabe, Brian and Nicole Albert, Colin Albert, Brian Higgins. They are suing Karen Reed and Aiden Kearney, Turtle Boy, for defamation, saying they were falsely implicated in O'Keefe's death. So that's an interesting one. And then number 4, we have the one we just talked about. Karen Reed is suing the state police in the town of Canton in Bristol County for negligence, civil conspiracy, and wrongful prosecution. That was just filed last week, and that's when all the text messages came out. So what do you think? Let's talk about the wrongful death suit quickly. What do you think about that one? Do you think there's any merit in it?
No, I still think that they don't have enough evidence against her. Now, just to explain to the audience again, you can have a criminal case, and when that's over, even if the defendant is found not guilty, you can still sue them, and there's a lesser standard. And we saw that with, I always hate to bring OJ up, but we always have to do that. He got found not guilty in the criminal trial, but he was found responsible in the civil lawsuit. There was the actor, the star of Beretta, was Robert Blake. Same thing. He was accused of killing his wife. He got found not guilty, but they won the civil suit. And we always talk about it's a lesser standard. If civil suit, it's not beyond a reasonable doubt. It's preponderance of the evidence. And I always say it's as if you were a scale. And in a civil suit, if 51% of your gut goes for the person's responsible, and 49 says not so sure, you go with the 51%. But criminal, it's a lot higher. Beyond a reasonable doubt is a lot higher. So it is easier to prove a civil case than it is a criminal case. However, I'm still not sure that they really have the evidence against her and were nailed. I just think there's too much. I think the investigation was so botched. That's another thing. If Proctor done everything right and they, got evidence against her, it would be, he did a disservice to the prosecution. If she was genuinely guilty, he would have done a disservice by not doing a good investigation. So I'm just not, I think that's going to be, you're probably in the same boat as me. We've given up long ago trying to guess what a jury will do. I've been wrong so many times, but I would say that that's not the strongest of civil cases against her on the wrongful death.
Yeah, and it was also filed down in Plymouth, which, you want to get as far away, you got to get far from Dedham as you can. So I think that may make a difference. It depends on the jury, and it also depends on how they present the evidence with the science and the data and the car. And still, though, Michael Proctor's text messages and all that will come in, so a jury may not want to award anything. So it depends. So we'll look that one. I think you're right. It can go either way.
Yeah, I wouldn't bet the farm on it. Like I say, I'm leaning towards saying it's not the strongest wrongful death case, but I also wouldn't rule out they could be successful too. You never know.
Yeah. So number 2 is Karen suing 5 witnesses in federal court. So you got the House defendants for alleging a coordinated effort to frame her. I don't think they're going to have enough evidence for that as well.
No, we never were able to put it together. And it may be true, but I don't think we would have heard it all. And maybe they'll uncover new evidence. But during this last 4.5 years, I haven't found, other than, boy, it looks really fishy and it doesn't pass the smell test. And my hunch is that, it was a coordinated thing. The evidence just, they were never able to get the evidence together, particularly because there wasn't any kind of good investigation done at all. And, but yeah, I think that could be, unless I learn of some new evidence, I don't think that's the strongest case that she would have there.
Right. You'd have to have the dog. Remember the whole dog bite thing?
Right. And that was unbelievably fishy that they said that it looked like he had been bitten by the dog, which would be proof that that he was assaulted in the dog. And it was kind of unbelievable that they had a dog for, I'm a dog lover. I I own some.
I
Doberman.
heard the dog barking in the background.
They ruin every video I have, but they.
I love that. I love
right.
it. Let's say hi to, what's his name?
I'm sorry. I've got like the door, like I got chairs against my door so they don't break through. But they,
oh, that's okay. If they did, actually, we'd get more views.
But as a dog lover, I can't believe that the family there in that house had a dog for 7 years, and all of a sudden this death happens, and suddenly they rehomed the dog, and it's somewhere else. We don't know where it is, and it's kind of when somebody else is taking care of it. And they would that whole that was very, very strange.
Yeah, a lot of jurors thought so too.
Yeah.
Yeah.
But anybody who has a dog, the idea that you'd have a dog for 7 years, and just, you'd have to, pry me away with a crowbar from my dog. So.
Yeah, I can't imagine rehoming any pet, to be honest. So I grew up with dogs. I have 3 cats now, so I can't imagine. Well, actually, I could get rid of one of them. I'm just kidding. For scratching my furniture. But number 3, the third case, Jen McCabe, Brian and Nicole Albert, Colin and Albert and Brian Higgins are suing Karen Reed and Aidan Kearney for defamation. Now that might have some standing.
You and I may finally disagree on something. I don't think defamation again is basically an intentional lie or just total, reckless disregard.
Disregard.
And so I'm not sure that they can. And defamation. That's why defamation lawsuits are notoriously difficult to prove. It's very rare. They're successful once in a while, but it's pretty rare. And they would have to show basically that Karen Reed or her defense team knew that they weren't responsible for it and for any wrongdoing, and they intentionally lied about it, or they were incredibly reckless about it. And the fact that she and her defense counsel kind of, raised it enough times, like the possibility, even though they didn't have any definite proof. I'm not quite sure they get over that, though, because, again, you're not going to be able to show that she knew that they were, innocent, did no wrongdoing, and this was an intentional lie on her part. And so then you could say, well, that was kind of just an absolute reckless disregard for the truth. I don't know. There were enough clues where she couldn't prove it, but where you couldn't say it was absolutely, totally reckless. The idea was just crazy.
Yeah. What about Aidan Kearney, Turtle Boy, though? He went off. Like some of the stuff he said. Defamation.
Yeah, he has a kind of a different approach than what I would.
I
would use, and he's kind of, but it's kind of a mixed bag because he's one of the people who really, one of the initial defenders of Karen Reed, who really alerted the public about not everything is done on the up and up in this case. And without him, I don't know. There's a lot of people who.
And of course, that's today's Law Lunch. And thank you to Peter Ellikin, and you can also find that full interview on my channel. Well, if you found this legal breakdown helpful, subscribe, and I'll see you tomorrow at noon for another edition of Law Lunch with Margaret McLean on The Margaret McLean Show. And enjoy. I think the weekend's almost coming up, and the 4th of July. I'll be doing it all week. See you soon.